Preferences. All right, so we get a chance to talk about this. Preferences are different in a receivership than they are in assignment, than they are in a bankruptcy proceeding. And I don't know if anybody here can pick it out right away what the differences are. Give me a second. In a receivership action, there's no intent required. In assignment, you need intent. Of course, we talk about 4 months. When we talk about 4 months, we mean
120.
You're right. Sorry, it is. It's 120 days. 120 days prior to the date of the action, and that's the same for assignment. 120 days before the date of the filing of the deed. And actually, I don't even know if that's clear. It's the date before filing the deed or the date before the deed was executed. They're going both ways. On account of the pre-existing debt, which means that you had to, that creditor had to owe money previously. And that payment allowed that creditor to get more than everybody else who didn't get paid to collect. That's clear. That's more than they would get if the company was liquidated. They get paid something somebody else didn't. That's really a preference. And here's the other part that's important. This is what's in the receivership part, but not in the assignment part. Knowledge. That creditor has to have a reasonable idea of what's going on. They have to think, this guy's going insolvent. You don't need that in assignment. You don't need that in a bankruptcy.
Preference is very simple. I have $5,000. I owe my mom $5,000. I owe you $5,000. Who do you think is going to pay? My mom. If I do that within a certain period, and she has a legitimate debt, so do you. And if I do that within a certain period of time, prior to an insolvency proceeding, they can reach back to a level playing field, and they can go back a year for an insider with my mom, or 90 days or 120 days of an assignment, and go back and reclaim that to a level playing field, because equity is equality. Okay, so you got to pay everybody the same. You can't favor your mother. You can't prefer mom.
So that's a very good general concept. But these cases are litigated all the time because there are nuances. Here, for instance, did the creditor know that they're going to go insolvent? In an assignment case, was there intent involved? And those, we fight about it all the time. Usually it's settled, but they fought about it all the time. Another thing that's key in a receivership preference claim that's not an assignment, there's actually a defense. It's actually a statutory defense, which you don't have in assignments, which is settlement. New value. The new value defense. We have that in bankruptcy, where if the creditor got paid $100 on 60 days prior to the receivership action, but yet 30 days prior to the receivership action, they give $50 in new value, that $50 offsets the preference. That's what they call the new value defense. We have that in bankruptcy. It's statute, it's by the code in bankruptcy. It's in the statute in receivership actions. It doesn't exist. Maybe you can find it in case law in the science. It's not in the statute.
David, does it have to be subsequent new value
Yeah.
as in the bankruptcy code?
Yeah.